Good evening. Welcome, everyone. My name is Wendy Zun, and I am the co-president of the League of Women Voters of Wilmette. Welcome to our Voting Rights, the Filibuster, and the Future of Democracy webinar. We are so glad that you have joined us to learn more about this timely topic, a topic central to the League of Women Voters' primary mission, to ensure that all eligible citizens have the opportunity and information to exercise their right to vote. We'd like to thank our co-sponsor for tonight's program, League of Women Voters of Glenview-Glencoe, and all our neighboring leagues for their support of this event. We are grateful to you all for your continued partnership. Tonight, we are fortunate to have Professor Tonja Jacobi, Northwestern University School of Law professor, to share the history, use, and misuse of the filibuster and its impact on pending voting rights legislation. Tonja Jacobi is a professor of law at Northwestern Pritzker Law School. She has a PhD in political science from Stanford University, a master's from the University of California, Berkeley, and a law degree with first-class honors from the Australian National University. Professor Jacobi specializes in Supreme Court judicial behavior and public law. Her areas of interest include judicial politics, Supreme Court oral arguments, criminal procedure, legislative process, and constitutional law. Combining doctrinal, empirical, and formal analysis, Professor Jacobi examines how judges respond to institutional constraints. In particular, she is a renowned expert in Supreme Court oral argument. In a series of empirical studies covering 60 years of arguments, she has identified patterns and prejudices in judicial and advocate behavior and has shown that case outcomes can be predicted based on those behaviors. She has published in 50 peer review and law review journals and is the co-founder of SCOTUSOA.com, a website devoted to empirical analysis of Supreme Court oral arguments. She also regularly writes op-eds in major periodicals such as the New York Times, Bloomberg, and the Washington Post, analyzing Supreme Court behavior and implications of the separation of powers system more generally. She has had a series of contributions published in the last year on voting rights, the filibuster, and democratic reform. Tonight's format will be a 30-minute talk by Professor Jacobi, followed by a question and answer period. You are welcome and encouraged to submit your questions to the chat. Your questions will be moderated by our team and forwarded to our speaker. Without further ado, welcome Professor Jacobi, and thank you for being with us here on this very cold Chicago evening.
Thank you very much for having me, Wendy. So I've been asked to talk about voting reform and the role of the filibuster. And I'd like to add something to that, which is the Supreme Court's role in all of this. So I think that a number of us are probably feeling a little downcast at the moment after the failure to pass the For the People Act recently due to an inability of Congress to overcome, or an unwillingness, I should say, of the Senate to abolish or reform the filibuster. I also want to draw your attention to another aspect that is also concerning, and that is even if this legislation, which is vital legislation, and I'll talk a little bit about what it contains and why we need it so much, but even if that was to pass, there's a very good chance that the Supreme Court would strike down most or all of it, or large important parts of it. And so when we talk about voting reform, we have to think about the court as well. And we have to think about, there are a lot of proposals out there to reform the Supreme Court. And there are concerns on either side of that issue. But it's very difficult to think about voting reform without thinking about what the court is going to do as well. And so I probably will depress you a little bit on the prospects of what the Supreme Court is likely to do, even if voting reform is passed. But at the same time, I'll try and end on a positive note in terms of what can be done. And I think that organizations like the League of Women Voters are vital to actually changing what's going to happen on the ground. We need to do, fundamental sort of get out the vote and get people engaged in these issues. And that's really the only way things are going to change. And I'll talk in particular about, where some of that effort should be focused. Okay, so that's sort of, I just want to add in that kind of aspect to the problem, that the problem is not just, the structural hurdles in the Senate, but there's also this other big hurdle that's out there, and that's the Supreme Court. I was asked just before getting into the heart of the topic to also say a few words about Justice Breyer. Justice Stephen Breyer is about to formally announce that he is retiring, and of course this has already been revealed to us in today's news cycle. And as a Supreme Court person, I thought I was happy to say a few words about what his role has been on the court, and what is likely to change with his retirement. He is a moderate liberal on the court. So we have on the Supreme Court at the moment, we have, as I'm sure you know, 6 conservatives, 5 of whom are pretty extreme conservatives. The Chief Justice is quite conservative, but moderate compared to the others. And then we have these 3 liberals, and Justice Breyer is definitely the most moderate of the 3, but the 3 liberal justices aren't exactly extreme. Like, there's not a balance on the court, even forgetting about the arithmetic, but just in terms of the ideological distribution. The court is far more tilted to the right, not just in numbers, but in terms of extremity, I think. And so Justice Breyer is quite a moderate liberal, even among those moderate liberals. And we see this in how he has quite often joined forces with the Conservatives and voted more often with the Conservatives than either Justice Kagan or Justice Sotomayor or Justice Ginsburg beforehand. And he has just had a very sort of moderate role on the court, an important role. And one of the things that he came to the Supreme Court as an expert in the administrative state. And ironically, he is leaving the court when much of that is under challenge. There's a case before the court this term called Becerra, which is potentially a major challenge to the way that administrative decisions are being decided. And so it's interesting time for him to be leaving. The other thing about Justice Breyer that's worth noting was that he's been a very pragmatic justice. So if you look at the way he reasons, he often sides with the Conservatives on criminal law issues, criminal justice issues, because he's trying to think about, okay, what is the impact going to be of these decisions? What incentives are we setting up? We don't want to, hamstring the police too much, but we also don't want to set up bad incentives for them. So he's always trying to find sort of very pragmatic solution to these sort of problems that roil the country. And then the one thing I really wanted to mention about Justice Breyer, something that I've studied in depth, is his humor. He's quite unusual on the court because he's quite self-effacing in his humor, and that's very unusual. It's a very status-driven, hierarchical institution, and Justice Breyer adds a little fun to the court. He's happy to make fun of himself. He'll often ask these rambling questions, then he'll get to the end and say, well, I don't know if any of that makes sense, or if there's any of that you want to answer, but feel free to go ahead and try, or something like that. And he often gets a laugh for making a little fun of himself, and that is definitely something that I will miss as he leaves the court. It's not going to make a huge difference in terms of case outcomes. He's expected to be replaced by another probably fairly moderate liberal. President Biden has promised to appoint a Black woman to the court, which is an exciting development. But there's still going to be, whoever it is, she's going to be one of 3 liberals, and on a court that's becoming more polarized. So it's more, the person is going to be much younger, and so can be on the court for much longer. Justice Breyer is 83, so his time to retire was definitely coming. So, and I'm happy to take questions on that at the end, but I just want to say a few words. I was asked to say a few words on that. Okay, well, turning to our topic of voting rights reform and what are the prospects, particularly given the filibuster and as I mentioned, the role of the Supreme Court. I think there is considerable reason to be concerned, and if you've been listening to some election law experts and other experts in the area, they've come out with some pretty stark statements about, the future of democracy being really under threat. that January 6th, the insurrection on January 6th, was just a sort of a dress rehearsal, for example, and some survey evidence has come out certainly recently in support of that. So 58% of Americans surveyed recently said they believe that democracy is in danger. And only 20% of Republican voters believe that Joe Biden is our legitimate president. And 1 in 3 Americans believe that violence against the government is justified under conditions like that. So I think people are very much concerned about whether there'll be another insurrection, maybe a more successful one next time. But I actually think while that is a concern, it's also quite possible that we could have the democratic process undermined in either the midterm elections or in 2024, not through violence, but through violence being done to the democratic system. And so that is already well underway. So there have been 34 laws passed in 19 states so far. There have been hundreds, almost 500 bills proposed in 49 states that weaken the right to vote, weaken access to the polls, limit access to the polls in various ways, that purge voters from the polls, often very quickly, like even if a person doesn't vote once, and often unlawfully. So one of the best examples of this was the governor of Georgia, Kemp, was Secretary of State at the time that he was running for governor in the last election against Stacey Abrams. And he purged 500,000 people from the rolls in one day, and 200,000 of those were later found to be unreasonably purged. So that's one example of what's being done. Access to the polls are being limited through rules such as abolishing same-day registration, limiting the number of actual polling stations, particularly in minority areas, introducing photo ID laws, which also disproportionately impact minority voters. Even really petty things like, not being able to hand water to people waiting in extremely long lines which are predictable on the basis of race as well. So that's pretty problematic. So these are laws that are being passed, and they're directly, I think, motivated quite clearly at restricting the voting base down, which favors Republicans. And the Supreme Court has allowed these laws on the whole under the guise of protecting the vote from voter fraud. And Donald Trump brought 20 lawsuits on that pretext, and they were all unsuccessful. And so that was shown to be without much basis, but nonetheless, the Supreme Court has okayed legislation to the same effect on that pretext. And so that's one thing that the Supreme Court is doing, is it's allowing these sorts of restrictions to be introduced at the state level. And at the same time, it's been whittling down voting access legislation at the federal level. So the Voting Rights Act has been restricted by the court already in terms of what's called the pre-clearance requirement. There used to be certain procedures that states that had a record of discriminating against African-American voters in particular had to go through. Anytime they wanted to change their election rules, they had to be pre-cleared by the Department of Justice. And the Supreme Court struck that down as unconstitutionally discriminating against the states. So that kind of discrimination is recognized. And as soon as that happened, almost all of the states that were, traditional discriminators that had things like, literacy tests, for example, for African-American voters in particular, they passed a whole bunch of restrictions, starting with, photographic evidence being required to vote, which just happens to coincide with, very high levels of minorities not having such photo IDs. And so at the same time as the Supreme Court is allowing state restrictions, it's striking down federal restrictions, and other restrictions that it's striking down are things like campaign finance restrictions. I'm sure you all know about Citizens United, but Citizens United was just the most famous of those cases. The Supreme Court has struck down most elements of campaign finance requirements that just sort of allow us to have transparency as to where money is going and where it's coming from. And so, for example, the Supreme Court said there used to be aggregate limits on how much voters could, and when I say voters, companies, etc., because companies have been deemed to be people for this purpose, how much the aggregate amount that any one person or company could contribute was struck down because it was unnecessary, because there are limits on how much can be given to each candidate. And I think the next thing that they will do is they will strike down the limits on candidates, how much can be given to each candidate, because it's ineffective without the aggregate limits. So you can see the sort of prestidigitation that's going on in those kinds of rulings. And so what can be done about this? So the Democrats proposed the For the People Act, HR 1, which has been proposed for the last couple of years. And that did a lot of things. It enabled guaranteed same-day registration for people. So even if they have been purged, even if they've been purged unlawfully, they could just come in and register and vote at the same time, which is something that the Republicans don't like, obviously, because that makes access to the polls much easier. It set up election security measures, like we all know about Russia's attempt to interfere with the vote. It set up mechanisms to track dark money, so money that's being contributed to politicians in ways that that is very hard for people to know about and hold people accountable without that kind of legislation. What else does it do? It also restricts gerrymandering by setting up independent commissions. So rather than the politicians choosing the voters choose the politicians. And I could go on. There's 1,000 pages of protections. Also, tax returns have to be made public by the president and vice president candidates, for example, and other guides to misbehavior, but not just by electors, but also by Supreme Court justices and so on. So there was a lot that was being done in this legislation, but as I'm sure you're all in the know about, this failed to even be put to a vote because of a filibuster. And the filibuster, Senators Joe Manchin and Kyrsten Sinema were under a lot of pressure to sign on to filibuster reform, or at least not applying the filibuster to this type of legislation, and they refused to do so. And so the HR 1 never received a vote. It's just been filibustered. Okay, so where does that leave us? I just had an op-ed come out on Monday arguing that it's all very well focusing on Manchin and Sinema, and Sinema's in Arizona, she's been censured by the Arizona Democratic Party, for example. But we have to recognize that those two senators come from states where they're not particularly, blue. And so they're under a lot of pressure. And so what I was arguing is that they're not the only two senators that should be under pressure here. So we've got these three moderate Republicans, Lisa Murkowski, Susan Collins, and Mitt Romney, who all have these reputations as being moderate and caring about voting rights and being reasonable, and they're not being put under pressure at all. So I did a count of how many newspaper articles refer to voting rights in all of the major newspapers, and this is true. If you just look at the Washington Post, if you look at the New York Times, etc., the same pattern persists, and that Joe Manchin gets mentioned about more than six times as often as any of those Republican moderate senators, and if you put them all together, the mentions of those senators adds up to less than that of Kyrsten Sinema, who actually gets a lot less attention than Joe Manchin just because she's newer. And so, and those three senators are able to skate by and basically avoid the issue by only talking about the filibuster. They're not being asked, do you believe that people should not be able to have same-day registration? Don't you care about making sure people are illegally purged from the rolls, et cetera, being asked those questions, because they're just allowed to sort of duck the issue and talk about how the great tradition of the filibuster, which I'll get to next. So my argument is that more pressure should be being put on senators who claim to be moderate within the Republican Party as well to actually address, do you care about access to the polls? Right? Do you care about the fact that democratic institutions are being unraveled? And let's, don't just talk about the filibuster, talk about the actual substantive issue, and that could, and so Susan Collins, for example, she's in a blue state, she's in Maine, she lost a lot of her percentage in the last election, so there should be a lot of pressure being put on Susan Collins, but she's barely mentioned, barely gets any attention, and so she's allowed to sort of hide away from this issue. So I think in terms of what we can do about this, that is one area that should be focused on, is focusing on those three moderates in particular. There aren't that many moderate senators anymore. Capito is the other one, but she doesn't really have a reputation for, particularly protecting voting rights. Those three senators ended up voting to have supported various pieces of voting rights legislation in the past. And so I think a lot of pressure could be put on those. So that's in terms of, one avenue for redress. Okay, so let's turn to the filibuster and talk about that. So a lot of the time when people talk about the filibuster, they talk about, tradition. We shouldn't mess with these long, important institutions. And this is practically part of our constitution, and et cetera. And it's really just not true. So in terms of the biggest tradition that the filibuster has been used for is to suppress voting rights, particularly leading up to the Civil Rights era, and the passing of the Civil Rights Act and the Voting Rights Act took decades longer than they otherwise would, because there were filibusters constantly to stop that kind of voter protection being passed back in the 50s, in the 40s, in the 30s, etc. So that is the greatest tradition of the filibuster. The other thing is the filibuster really hasn't been around that long. It's not like it was there at the founding or anything. It was actually an institution, a mechanism that was started in the House. And the House abolished it because it made the House completely unmanageable and could get nothing done. The House had a reputation as a do-nothing institution, and the House ended up abolishing it. And so it was much later that the filibuster came into the Senate. It's only been around for about 100 years. And it was introduced, and it's also been reformed multiple times over the time. At first, there was no such thing as a cloture vote to actually end a filibuster. And then the numbers required for the cloture vote have gradually decreased over time. So it's down to 60%. It was previously 2/3, for example. But the most important reform of the filibuster is something that was well intended, but is actually part of the problem. And the problem is that because the Senate had this reputation as this do-nothing institution, it was its turn once it adopted the filibuster, the endless ability to talk, was because it was seen as a do-nothing institution, and the Senate wasn't getting anything done, this reform was introduced to have what's called a two-track system, whereby the Senate could go about other business while pretending to have a filibuster. So on one track of voting, a filibuster would be occurring on whatever the issue was, so voting rights. And then at the same time, the Senate could go about, passing resolutions and doing other things, doing other Senate business. And so the effect of this was, yes, to make the Senate more effective in terms of getting things done, but it also made filibustering costless, because it's no longer like Mr. Smith Goes to Washington, where people have to actually stand there and talk for hours and hours until they collapse. Instead, you just deem that you are holding a filibuster and nothing actually has to be done. And so with costless filibustering, guess what? It happens all the time now. And so if you look at cloture votes, which are attempts to end filibusters, we can count those as sort of a proxy for how broad spread the filibuster is. And prior to this reform in 1972, there had never been double digits of cloture votes in any Congress. And now every year since then, it's been triple digits, and it's up to the thousands now in the most recent Congress. So attempts to end filibuster are so massive because it's completely costless to filibuster. So one of the reforms, and this is a reform that Joe Manchin said he would actually support, would be to force people to talk to actually filibuster, to actually continue talking to stop legislation. And I would add that another reform that could be passed, I think, at the same time would be to have a relevance requirement. So the other thing people used to do when they did have to talk is they'd, read from recipe books and read from telephone books and so on. They just had to be up there talking. And there's no reason why the parliamentarian can't be given power. The parliamentarian does this kind of thing all the time, is to say, no, that's irrelevant. And so therefore you have to actually talk on the topic. And so getting back to my point about holding these moderate senators accountable, we would actually have to have the Republicans get up there and talk about why they don't want access to the polls, broad access by people, rather than just ducking the issue and just deeming to be having a filibuster. So that's a reform. I think abolition of the filibuster is a laudable goal, but I don't think it's a very practical one in the current Congress, and probably not in the near future, because the expectation is that there's not going to be an increase in democratic power probably in these midterms coming, or perhaps even subsequent to those, and we can talk about why that is. But perhaps reform is possible of that kind. President Biden has also come out in support of the first idea of making people actually talk to filibuster. But I think until there's pressure put on Republicans to actually, like all Republicans, to actually say, oh yeah, I'm opposed to voting rights expansion, expansion of access to the poll, protection of voter rights, then I don't think that it's going to be very costly for them to oppose that either. So I think there are kind of a couple of directions that we can go in that hold the possibility of future change. But I think that there was the hope going into the 2020 election that there would be this huge swing to the Democrats, and the Democrats were actually able to really bring in comprehensive reform of this kind. And it's not just the Voting Rights Act, the For the People Act, I should say, that really needs to be passed. But there are 4 million people in DC who are disenfranchised. So there's a bill to make DC a state and enfranchise those millions of people. There's also a bill to put in a new pre-clearance system, so that states can't pass these pretty oppressive measures that are clearly anti-democratic. So there's other legislation like that as well, and I think that's going to take larger majorities. And the problem, of course, is it's a catch-22, because what's going on with these voter rights restrictions is that it's making it very difficult for majorities to actually be expressed. So even when there are majorities, so we've seen, of course, in presidential elections, in Trump and Bush, that that the person who lost the popular vote nonetheless was deemed to be the winner. But that's the electoral college system, that's in the Constitution. But what we're seeing is the same thing happen at the state levels, that we're starting to see minorities elected even when they don't have a majority of the vote, through similar sort of mechanisms being introduced at the state level. And so there's a lot that needs to be done to combat that trend of minoritarian government. And that's going to take a huge get out the vote drive, because Democrats are at a huge disadvantage structurally. They what's called self-gerrymander, essentially. They tend to live in big urban enclaves where there are huge swings, and then Republicans are able to get by on much smaller margins. And so essentially, just by the nature of where different people live, there's sort of an effective gerrymandering, self-gerrymandering, and then add to that all of the gerrymandering and then all of the restrictions of stopping people voting. So it's going to take far more than just a majority in order to actually express that majority in terms of getting elected. But I think the thing to focus on for the League of Women Voters and other like organizations is to focus on local elections, state elections, and pressure at those levels as well. I think we all tend to focus on the national level a lot, because it's where the sort of the big players are. It's where and I'm guilty of this. I talk all about the Supreme Court. All my research is on the Supreme Court, but the district courts and the state courts really matter. And in terms of, challenging these sorts of pieces of legislation, it's really at the local and state level that more has to be done. And so that is, I guess, where I would point people that there are different people we should be putting pressure on. That's one thing. And then secondly is, really trying to focus on what can be done at the local level, because this is going to be, I think, a generational fight. I think the hope was that in 2020, there'd be this big shift and there'd be all this reform and things would really change and we'd, ride back this tide of anti-democratic movement that's happened in the last 4 years. But it hasn't just been in the last 4 years. In the last 4 years, we saw a lot of democratic institutions being directly challenged by Donald Trump and his particular style of leadership. But it's actually been happening long before that in state legislatures and at the Supreme Court. And so I think it's going to take a long time. We have to sort of be ready for a big fight, like the civil rights era, to, fight for voting rights access for everybody once again. So I guess that's what I will end on and open up for Q&A, is that, it is a little bit dire, but at the same time, I think, there is work to be done, and it hopefully will make a change in the long run. But at the moment, we're sort of caught in a bit of a catch-22.
Thank you very much, Professor Jacobi, for sharing your wisdom on this complicated procedural element that greatly impacts the work of the U.S. Senate. Attendees, now is your turn. Please submit any questions to the chat. And I believe Professor Jacobi will answer questions on the filibuster and also on anything she's spoken about today, including the Supreme Court and oral arguments. So Mary, if you want to ask some questions from our chat.
We do have some questions via text and the chat. So let's start with the one about the Supreme Court, since that was in the news today. The question reads, what does Professor Jacobi think the impact of expanding the Supreme Court would be?
I actually wrote an op-ed on this, putting forth a pretty controversial position. So there was this proposal to add a couple of seats to the Supreme Court, and there are good reasons to be concerned about that. If it's just clearly to, we get back a liberal majority on the court, there's concerns about legitimacy and what have you. But I actually put forward an argument that the Supreme Court should be expanded to 15. And so there should be 6 additions. And one of the reasons is partly that the Supreme Court just doesn't do enough. It's not just about partisan balance. It's that the Supreme Court takes less than 70 cases a year. There are hundreds of thousands of cases every year in the federal and state courts that it's meant to be overseeing. It's meant to be the apex of the judiciary. And if justices sat in panels of 5, they could take a lot more cases. A lot of countries have panel system where they don't have to sit en banc, which means all of the justices sitting at the same time. With nine justices is a lot to hear a particular case. So we could have 3 panels of 5 changing constantly. And if the court agreed, they could have all of the justices review the panel decision. And so there are really good institutional reasons to think about changing the court, because the court really doesn't do nearly enough. So it's not just about partisan balance, but happily it might have that effect as well and I think the other thing I just want to mention is that part of the pushback of that is, how illegitimate it would be to pack the court. It would harm judicial independence, etc. But arguably, the court has been packed in recent years. So the last 3 judicial appointments are all pretty procedurally unsound. Everybody knows about Neil Gorsuch having the seat that was meant for Merrick Garland because the Republicans refused to hold hearings because it was over 10 months before the election in that case in 2016, but then 6 days to push through Amy Coney Barrett after Justice Ginsburg died showed, just the total hypocrisy involved there. But also Justice Kavanaugh got his seat, not just with the allegations of attempted rape that the FBI didn't properly look into, but procedurally there was said to be a lot of pressure and negotiations with Justice Kennedy to vacate his seat on the promise as to who would take his place, one of his clerks, or specifically Judge Kavanaugh then. And so that's actually, I think, the most procedurally unsound. So my point is just that there's already kind of bin packing of the court going on. So this idea of, oh, we must protect the status quo because it's perfect and holy is actually pretty misleading.
In your talk, you did reference the low cost of the current filibuster. So I'm going to combine a couple of questions here on the filibuster. So if they were to move to a more high cost filibuster, would people like Manchin support it? And if he wouldn't, why not?
Well, Joe Manchin's actually said he is open to that one, the first reform that I mentioned about actually making people talk, getting rid of the two-track system and making people talk. Joe Manchin has said he would support that. Kyrsten Sinema, I do not believe, has committed on that issue. And the moderate Republicans, I don't think, have really been pressed on that issue, the three that I mentioned. So I think that is something that could, even if, say, Kyrsten Sinema opposes but Joe Manchin supports, if you could pressure, Susan Collins, given her electoral position and her reputation for being moderate, for example, or Mitt Romney or Lisa Murkowski, who really is quite moderate on a lot of these issues, and is being challenged from the right, possibly for that reason. But then I think that reform, but also the others that I suggested, I think do have a reasonable chance. And so that would make it much, we would see a lot less filibustering, that's for sure. And so, I'm sure the Republicans would still put on a filibuster for something like the For the People Act, because, they're addicted to minoritarian power, not just in terms of the filibuster, but, in terms of suppressing the vote. And that's, that's pretty clearly correlated with, Republican success and a decreased voting base. But they couldn't do it forever, it would make it more difficult. And there's certainly a lot more that the Senate could get done.
Okay, great. Thank you. So we have another question here. There's been proposed legislation about the structural issue of who makes a decision about the election, such as suspending the use of secretaries of state in favor of a partisan House of Representatives. You said the Supreme Court is somewhat hands-off with voter registration, ID, polling places, and so forth. But do you have a view of how the Supreme Court would address changes to the means of counting the votes?
That's a good question. I haven't come across that question before. So I think it depends how it's done. We've seen in the past some of the conservatives on the court pretty resistant to those kind of institutional reforms. So, for example, we had a case a few years ago about gerrymandering and about those independent commissions. And there was a case that was sort of a very specific issue related to that, where the conservative position was not successful, but it was a close case. It was a 5-4 case. And the independent commissions were upheld, but there was a lot of sort of murmuring, and there has been subsequent challenge. And I think it might be coming this term, actually, another question on the same issue, like on these independent commissions and trying to attack them from another position. And I think it's pretty clear that the conservative justices do want to challenge those sorts of solutions as well. And there are things that they point to. They don't come out and say, we don't want this kind of reform. They say things like, oh, the text of the Constitution clearly gives this power to legislatures and therefore it can't be given to an independent commission. So, arguments like that. So I think, I wouldn't like to sort of say that all of those institutional changes that the question referred to would necessarily be able to be challenged in the same way, but I think there is a propensity of the court to be open, of the current court, and the court has become much more conservative since that decision that I mentioned. So I think that the direction I would expect there would be challenges on that front as well that could be quite successful before this very conservative court.
Okay, thank you for that. A slightly different direction now. Are you aware of any cases that have the potential to get to the Supreme Court this year that could further impact voting access and fair elections?
There's nothing before the court right now that the court has accepted that that I think directly address those issues. There are related issues. So, for example, there's one case about the capacity of legislatures to censure their members, which is, it's a different issue, but it sort of goes to the heart of, you know, this idea of legislatures having the freedom to act in different ways. And I think that that's an example where the court, you know, could restrict the capacity of legislatures to police themselves in this way, and that could herald a change in that direction. But there's nothing yet directly on, you know, voting rights in the, you know, of the kind that we've seen in recent years, where the court has, you know, restricted, you know, struck down part of the Voting Rights Act that's been, you know, that's been reinstated, you know, 6 or 7 times throughout the decades. So there's nothing directly on point like that, but I think there are, you know, you have to watch sort of, when you watch the Supreme Court, you have to sort of watch these building blocks that are gradually being developed in those areas, and you have to sort of read the tea leaves. And so, you know, if you see a case like that, you think, okay, well, that could be the beginning of something, but there's nothing directly on the challenge.
Okay, here's a question near to my heart since I used to live in this place. What are the chances of, do we have any chance of making DC a state? What would have to happen in order to make that possible?
So under the current political situation, no. I mean, there is a bill to that effect to begin that process of making DC a state. I think at the moment, I think that's part of the sort of generational battle that I mentioned in my talk, that I think it's on the table, it's being pushed, but if we can't even do, you know, same day registration, then, you know, then we're not going to have DC a state, because it's pretty clear. And Puerto Rico is another one that, you know, millions of people disenfranchised. But I think it's quite, and I actually think the best idea would be to push both of them at the same time. So then you have 52 states. And so you could have like calendars with a state per week, and you could have playing cards and things. It's such a nice round number, you know. But the Republicans know what that would mean. Like, if that would be 4 more senators who would be pretty solidly Democratic. So they're going to fight tooth and nail to stop that. So at the moment, I don't think that's on the cards, given the current political alignment, and given, quite frankly, in 2022, in the midterms, it's not definite, but it's very likely that the Democrats are going to lose some of their power. And so we have to be prepared for that. And so not anytime soon, I guess.
Thank you for that. Another question is about, would it backfire on the Democrats if they were successful in getting rid of the filibuster altogether? When they're in the minority, won't the Democrats want to have the filibuster? Is that a reason not to get rid of it altogether?
I actually don't think so. So I think that what we've seen in sort of the last couple of decades is that Republican leadership don't feel the need to be consistent. So, you know, we saw that with the change of the filibuster as applying to Supreme Court nominees, for example. And the Democrats were thinking of doing this, and then the Republicans sort of kicked and screamed, and they came to some arrangement. And then in the end, as soon as there was a switch of power, there was no more filibuster of Supreme Court nominees. And so, you know, and we saw that with the Gorsuch Barrett, you know, nominee. You know, there's no, like, there was no blushing by Mitch McConnell for being completely inconsistent with what he had argued just a couple of years before. So I think I actually don't think that the filibuster will necessarily be respected if there was united Republican government and the Democrats were the minority that had, more than 40 seats in the Senate, I actually think that we might just see all these arguments about tradition go by the wayside. So, I don't think it's going to be very successful in the same. I also think Democrats, the nature of the division between the ideological division between Democrats and Republicans is overall, like, conservative means a lot of different things these days, but Democrats generally support government acting more, right? Bigger government requires government action, right? And so it's more in the interests of Republicans to be obstructionist than it is for Democrats. Like, sure, there are things that Democrats want to stop, but overall, on the balance of things, Democrats are better off if government acts, right? If government can act more freely. So this system of multiple veto points in the legislative process is a small c conservative value, right? It stops government doing as much. And so in the grand scheme of things, would Democrats be better off without the filibuster? Absolutely.
Okay. What is your thought about the impact or importance of televising the Supreme Court oral arguments?
Oh, that's a great question. So I think it would be good, because I think it would bring attention and accountability, to this really quite sort of secretive branch of government. Like, we don't see the only part of the process that the Supreme Court's decision-making process that we have any access to is oral argument, right? Everything else is done behind closed doors. They meet in conference, and we don't know until usually decades after a justice dies, and their papers are then sometimes made public, how the votes went down on cases from the 1960s, right? And so oral argument is all we have. And so I think it's important for that to be public. I think seeing, some of the justices are very concerned that this will, there'll be little clips taken out of context and what have you. But I actually think the average American understanding more of what the court does would help the court and actually see. I think one of the things that they would see is the Supreme Court, sort of the justices struggling to figure out how to form doctrine. It's not just all, I hate abortion, I like choice, right? It's not what they talk. They talk about how to craft a test, how to deal with difficult cross issues, etc. And I actually think seeing that the justices do actually deal with law as well as politics would be good for the institution. But ultimately, I think, you're part of a democratic system, and transparency is a good thing. There was a great reluctance for the court to make the oral recordings of the oral arguments available. And it only happened during the Rehnquist era. And there was sort of, and at first they were sort of released quite late. There was talk about releasing them all at the end of the term. And eventually the agreement was they would be released week by week along with the transcripts. And I think it's, the Supreme Court, I know a lot of the justices don't like what I do. I do a lot of empirical analysis of the transcripts to see, for example, the justices ask a lot more, or talk a lot more during the time of the advocate that they vote against. Like, they're using up the time of that advocate. Like, there's sort of strategic behavior. And I'm sure they don't like that, because they want to pretend that they're completely above politics and above strategy. So I can see why that kind of transparency and the accountability that leads to would make them uncomfortable, because it reveals, as the introduction said, it reveals their patterns and prejudices, and you can predict how they're going to vote based on things like so I showed, for example, that who the Supreme Court justice makes jokes about, like whether the advocate who is before them, they make something that causes the courtroom to laugh, is a really quite good predictor of how they're going to vote. So they're mean to the advocate. I showed that they're mean to the advocates that they're actually going to vote against, but they're also mean. They also make more jokes during the time of the advocates who are losing before the court as a whole. So not just losing their vote, and also the inexperienced advocates. So it's sort of a status thing as well. The elite boys club don't get jokes made at their expense, but there's also this strategic element. So I'm sure that they don't want more of that. If we could see their faces, for example, they'd have to think about, that sort of thing. But I think it's important. You know, they're an important part of the decision-making process of our democratic system. So letting the people see what's going on is a good thing.
Thank you. That was a great answer. They all have been, but I really liked that one. Okay. I think we're going to wrap up soon, but I just saw a question come in that's sort of a follow-on question. I've seen some people writing about the lack of diversity, lack of women among attorneys arguing in front of the Supreme Court. Have you looked at this in your analysis, and what are your thoughts on this topic?
Yeah, so we had I had this website that was mentioned in the introduction, SCOTUS OA, which stands for the SCOTUS Oral Argument, where I just put up sort of small, 1 or 2 page commentaries on what's going on at oral argument. And one of the things that we did was we would have a running tally each Supreme Court term as to how many female advocates appeared before the court, and then how many men named, John or James or what have you, the most common male names. And just the top 3 most common male names generally outnumbered the total number of women. So that gives you an idea. And we sort of took this idea from, there are more CEOs named John or James than there are female CEOs. So we're doing the same kind of thing for the Supreme Court advocates. And what we see is that it's not just that there are fewer women, but that the women that are there generally are arguing for the government. So they're working for the Solicitor General's office. And so we see that, women who go through the government route are given more access, whereas women who go through into the private sector are given even less opportunity to argue before the Supreme Court. And the number of advocates is going down over time as well. And the number of cases is going down, but even accounting for that, the number is becoming more and more of an elite boys club. The number of women is increasing, but just the diversity even among the men is going down. So it's become, and they, as I mentioned, they make jokes to each other and so on. And so it's becoming very undiverse, not just on things like gender and race, but even just in terms of, the breadth of applications that we hear. And I've even heard, justices such as Justice Sotomayor, for example, criticize having, first-time advocates appear before them because they don't do as good a job. And it's like, yeah, but this is really important. Like people who, for example, are representing a death row inmate and have been, for the last 15 years of that process, and that case makes it all the way to the Supreme Court. Like they should come and argue. And, they're not going to be as smooth. They're not going to be as practiced, but they're going to know everything they possibly can about that case. And it's also good that the Supreme Court hear from different sorts of people. And, and we've seen the Supreme Court justices are more and more restricted as to who they're currently all prior judges, except for, Elena Kagan was an academic and then Solicitor General. So, but, very Ivy League education and so on. So the diversity on the court has never been great, but it's not, it's not just on those sort of socioeconomic factors and education and so on, but it's, on what they did before coming to the court. There is, I will mention, if you'll allow me, like there are among the sort of the most common names of people who will be nominated to replace Justice Breyer, a couple of names which I don't think are very likely, but it's interesting they're being thrown into the mix, is one is Stacey Abrams and the other is Kamala Harris. And I don't think either of them are going to be the nominee, but it's interesting to just see, we could have someone from a really different background on the court, like not from Harvard or Yale, and not one of the prestigious lower courts as well. So it's an idea that's out there, but I don't think it's going to happen.
So final question is, who do you think it would be? Somebody wanted to know if you had any predictions.
Well, I have to admit, like I read what everybody else reads. I'm not an expert on the lower courts, who's in and who's out, but I read the predictions on this, so I can sort of convey what I've read, but I don't claim special expertise. Judge Ketanji Brown Jackson is probably top of the list. She's from the DC circuit, where it's not uncommon to come from. It's basically 3 judges: Judge Leandra Kruger from the California Supreme Court, and Judge Michelle Childs, who's from the South Carolina District Court, or yeah. And so they're the three big names. People like Stacey Abrams are much more out there. I mean, Stacey Abrams already running for governor, so I don't think it's going to be Stacey Abrams, though she's great. And so it's probably going to be, a very highly credentialed Black female judge who's, from one of the prestigious courts, which is great. Like, it's, wonderful to see that sort of, having an African-American woman on the court will be such a huge step in diversity. I don't think we need to worry about, this also has to satisfy various other forms of diversity, but yeah.
That concludes our webinar tonight. I'd like to reiterate our thanks to Professor Jacobi for sharing her time and talent with our community this evening. We are grateful for all that we have learned this evening. And I think one of the important takeaways from tonight is that if we want to protect voting rights, we must advocate at a national level, advocate at a state-by-state level, be a poll worker, be an election judge, register and inform voters, volunteer for nonpartisan election protection. And if you have questions about the League of Women Voters, I, along with my co-president, Ann Sullivan, am available for any additional discussion. As mentioned earlier, the League is focused on voting rights and voter education, and we would be happy to help you engage and work on this topic. To all our attendees tonight, thank you so much for coming. Stay well, stay warm, and have a good night.
Thank you for having me.